Tonight, Speaker of Parliament tears into Supreme Court judgment that permits Deputy Speaker to vote while presiding, insisting it is an absurdity and a reckless incursion into the remit of Parliament. We finally have secured details of the full reasons for the Supreme Court's judgment. We tell you why the Apex Court was emphatic. Ghana runs a system of constitutional and not parliamentary supremacy.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone and Prime Insurance. Rest assured, you are insured. On a day when the full reasons behind the Supreme Court's decision that allows a Speaker of Parliament, a Deputy Speaker of Parliament, full voting rights while presiding became public, the Speaker of Parliament himself has chosen to go public with a strongly worded statement tearing into the Apex Court. He accuses the court of delivering a judgment that is not only absurd, but a reckless incursion into the remit of Parliament. We'll have details for you shortly on the fascinating reasons behind the Supreme Court's decision that we are now beginning to learn much more of after securing a copy of the reasons. But first, what exactly has the Speaker been saying? Kweku Asante joins me with his statement. And Kweku, this is a statement that was posted on the official Facebook page of Parliament.
Right.
What does he say?
So this statement tears into the judgment, like you said, and also makes some comments about President Akufo-Addo's statement post the judgment. It starts by saying that I have resisted the temptation of making a comment on the judgment of the Supreme Court on the issue of the voting rights of deputy speakers when presiding. But the unfortunate and myopic comment of the President has compelled me to let it out. The SC decision is, to say the least, not only an absurdity, but a reckless incursion into the remit of Parliament. The trend of unanimity is equally troubling. It doesn't help explore and expand our legal jurisprudence. The President's comment is myopic, and unfortunately, it goes to worsen the schism between the executive and Parliament. The impartiality of the Speaker, Deputy Speaker, or any presiding officer has been treasured and fought for by this country throughout our democratic development. Mr. President, the issue being discussed is not about Parliament being above the law. Everyone knows that Parliament is not above the law. The executive and the judiciary are equally not above the law. The issue being discussed is the political question doctrine. It took centuries to detail out the strands of this doctrine, and the principles are settled to when and how this closed book could be opened. Please, I encourage the plaintiff to go for a review. So the Speaker goes on to criticize the judgment of the court, and also goes on to also criticize what the President said, and ends by urging the plaintiff who sent the matter to court to ask for a review.
And I find it interesting. The Speaker talks about this political doctrine that he talks about, the political question doctrine. We've been reading now details of the Supreme Court reasons that we are now secured, and the judges unanimously address that question in a very fascinating way. We'll be telling you shortly. They address the Speaker's concerns and argue why Ghana runs what they call a constitutional supremacy and not parliamentary supremacy, and that they were squarely within their rights as an authority in interpreting the Constitution to really pronounce on the matters that were before them. But also, there's something else to note in the Speaker's statement. It is instructive that the Speaker starts his statement with "Good morning, comrades."
Comrades.
You wonder, so was he addressing the NDC? Because we know among the NDC fraternity, that's how that the reference is made when you are addressing comrades. He starts that, but of course it's an official, Parliament website. I checked with Parliament itself, the Secretariat, on Public Affairs, and they clarified that the statement came from the office of the speaker. And so that's the speaker's position, they're taking on the president for his comment. So what really did the president say that has so angered the speaker, forcing him to comment? He himself acknowledges that he has resisted the temptation of making a comment on the judgment of the Supreme Court on the issue of the voting rights of the deputy speaker when presiding, but the unfortunate and myopic comment of the president has compelled me to let it out. So really, what did the president say?
We're being told that the decision of the court amounts to judicial interference in the work of Parliament. I'm not quite sure that the people who are saying this have actually taken the time to read the Constitution of our country. It says so in black and white. The legislative power of Parliament that is vested of the state, which is vested in Parliament, is subject to the provisions of the Constitution. All organs of the Ghanaian state, including me as the head of the executive, we are all subject to the teachings of the Constitution. There's no body in the Ghanaian state that is above the fundamental law of the land. It would lead to the very matter that we have striven so long to avoid, the concentration of power, of unregulated power in our state. We don't want that. We've had that experience before, and we brought about this constitution in order not to allow that to reoccur. So I'm astonished about how much public energy has been wasted, I would say so with the greatest of respect, been wasted in an area, on an issue where there is so much clarity. And I'm happy that the court, and I'm sure as you're aware, the Supreme Court, when it is declaring the meaning of the Constitution, and it does so unanimously, that is the most emphatic way in which the court can pronounce. And it is, I believe, a decision of 7 of the judges, and a unanimous decision declaring what the constitutional position is.
Let me bring in my court correspondent, Joseph Akable. We've been reading this document from the Supreme Court together. And by the way, I must point out that the concerns that the Speaker had raised, the concerns that we've had the majority leader also raise about insisting that the court had no business, as the Speaker calls it, to sway into trying to control what Parliament does. In fact, the Speaker's words where it was an absurdity and this reckless incursion into the remit of Parliament. The Supreme Court really exhaustively dealt with that in this judgment. Joseph. Hello, Joseph.
Yes, Evans. Hello, Evans.
Joseph, let's start from there, because that has been one of the most controversial issues. I read this document and I see that the Supreme Court took some time to thoroughly address that question. Tell us what you've been saying there.
So it starts from page 15 of the judgment, where the Supreme Court makes reference to Article 1101 of Ghana's Constitution, and it quotes that article. That article says that, subject to the provisions of the Constitution, Parliament may by standing orders regulate its own procedure, end quote. Now, the Supreme Court argues that the opening line, that is subject to the provisions of the Constitution, makes the standing orders of Parliament subservient to the Constitution. And it goes on to say that no arm of government is a law unto itself. It says everyone is subject to the Constitution. It additionally relies on Article 1.2 of the Constitution, Article 2.1, to say that it is empowered as a court to allow for citizens who hold a view that there is any law or any provision or any action by anyone that is contrary to the Constitution to bring an action to the Supreme Court for the Supreme Court to pronounce on the matter. So when it comes to any act that anyone claims is contrary to the Constitution, the Supreme Court has every right, and once everyone is subject to the Constitution, it can deal with any such matter.
And the thing that fascinated me also, the Supreme Court actually also anticipated that this debate will happen almost. And it makes the point that they would actually had no problem whatsoever declining to get into the matters if it was purely a case of parliamentary procedure. In fact, this is the part that fascinates me on page 9. It says, if the disparate interpretations proffered by the parties exclusively implicated the standing orders, procedures, and practices of Parliament, without more, we would have had no difficulty in reaching the conclusion that Parliament is and ought always to be the master of its procedures, orders, and practices without let or hindrance from the court. In other words, they were just saying to the Speaker, who is angry tonight, that we would have agreed with you if the case before us only had to do with your standing orders, procedures, and practice of Parliament. But the Supreme Court goes ahead to say, in such a case, these would have been matters that lie peculiarly within the domain of Parliament and would therefore not be matters appropriate for judicial determination. So there's actually the judges anticipated the Speaker's anguish and Harun Idris's anguish and say, we acknowledge your concern, but we acknowledge it to the extent that if it only had to do with parliamentary procedure, standing orders, and practices. But then they go on to say, Joseph, that they disagree that what is before them only has to do with parliamentary procedure. In fact, what they say is, however, to the extent that the challenge to these proceedings in the third issue are equally anchored on rival interpretations to the combined reading of Articles 102, that is a general quorum for Parliament to sit, Articles 104, that is the quorum to do business, and they introduce some terms, that is a non-voting quorum and a voting quorum, right, of the Constitution.
Yeah.
The only court mandated under Article 130 to interpret the rule and proper meaning of these provisions of the Constitution is this court. Consequently, this court will be failing in its constitutional responsibility and mandate if we were to avoid and or fail to provide clarity and direction and take cover under, and the Speaker of Parliament tonight has referenced this doctrine, under, this is how the Supreme Court terms it, under a so-called political question doctrine. You mean you're reading the judgment of the Supreme Court, it almost comes across as if they are responding to the Speaker tonight directly, but they had written this long ago. They go on to say, which is to say that it is a function of the principle of separation of powers that certain questions presented for the resolution of the courts that are expressly or impliedly constitutionally committed to the elected political branches of government of resolution be left to those branches because such questions may be said to be non-justiciable. And they go on to make the point. This is the point that I guess emphasize the point. It must be noted that the 1992 Constitution establishes constitutional supremacy as against parliamentary supremacy. And the parliamentary supremacy, as pertains in the United Kingdom, Parliament is sovereign, and all laws, decisions, procedures in Parliament are final and cannot be subject to the judicial review of the courts. The courts merely apply the legislation made by Parliament and may not hold an act of Parliament to be invalid or unconstitutional. Under our constitution dispensation, the sovereign people of Ghana have adopted for ourselves a constitution where it is expressly declared that the constitution, not Parliament, and these are the words of the judges, the constitution, not Parliament, shall be the supreme law of Ghana, to which all other laws must conform. Accordingly, they believe they have all the authority to make the pronouncements. And Joseph, so that is that controversial decision on the reasons why they went into the issue surrounding Parliament and the standing orders. But let's break it down now, Joseph. The case before them were in three parts. Let's take it one after the other. What was the first issue that they had to determine, and what was their reasons for coming to that conclusion that as far as counting or forum a quorum to vote on a parliamentary decision, you can count the Speaker? What was their reasons there?
I mean, just briefly before we get to that, the doctrine of political question that Kweku read from the Speaker's statement. I mean, the court responds to that at page 13, and they say that it has in a plethora of cases ruled that political doctrine question does not apply in this jurisdiction. And if therefore there's any matter that is raised that borders on whether a constitution has been breached or interpretation, the court will speak on it and will not apply the so-called doctrine of political question to ignore it, which is what the speaker had argued that this matter was not really about interfering, or it has nothing to do with someone being powerful than the other, but simply the doctrine of political question. On the substantive issues that came before the court, the first one had to do with the quorum formation. Now, what the court does is that it says that when you go to Article 1041, it says it imposes a quorum of half of all members, or in some places of the Constitution, says one half, and that is for decision making. And so the Supreme Court says when you look at Article 102, that says 1/3 of the members. Now, the Supreme Court explains that it means that the voting as a process in Parliament is placed on a higher level than other non-voting deliberations. Now, this is what the court says is to prevent minority members of Parliament from deciding on a matter that will have a binding legal effect. And so this quorum requirement, it knows, specifically excludes presiding members. That is the one that is provided for under 102. So it says excluding the one presiding. But it says when you go to 104, it simply says one half of all members of Parliament. It does not exclude anyone. And so this is the basis for the court to say that, look, when you compare the two, you see that non-voting deliberations are not at the same level as the voting deliberations. And it's for that reason, that's why the Constitution, in the case of putting a lower threshold for the non-voting deliberations, but set a higher threshold and did not exclude anyone from participating in it. And so that is what the court relies on to conclude that the Deputy Speaker, who is a member of Parliament, is not excluded by the Constitution from being part of the quorum for decision-making, which is a non-voting voting deliberation, which is higher than the normal non-voting deliberation, which is just 1/3 of the members of Parliament.
And then, so that's the first one. And then the controversial one, whether or not a Deputy Speaker can vote while presiding. And we know the decision. The decision is that he can. What were their reasons?
They make reference to the fact that if you look carefully at the Constitution makes the point that the Speaker cannot be a member of Parliament. They said that is not the case for the first and second Deputy Speaker. They again make the point that if you read 104(2) of the Constitution, it denies the Speaker an original or a casting vote. But it says nowhere in the Constitution is such a disqualification provided on the Deputy Speaker. And this specifically at page 22 of the judgment. It says the Speaker is disqualified not because he presides over proceedings. The court takes the view that the Speaker is actually disqualified because he's not a member of Parliament. That is how come it's not permitted to have either a casting or an original vote. And so the court says that the situation is very different from the Deputy Speaker of Parliament, and then makes the representation argument to say that he represents constituencies. And so once there's no such disqualification placed on the Deputy Speaker, the court concludes that he has every right to vote, and therefore will reserve that right for the Deputy Speaker to vote even when presiding.
Again, very detailed and sound reasoning by the Supreme Court. We're going to put the entire thing up for you on my jaw line so you can read it for yourself. And then there's a final one, Joseph. The Supreme Court was also asked now to pronounce on the validity or the legality of the decision to overturn the decision that I think approved the budget. Right? What did the Supreme Court decide there, and what was their reason?
In fact, it makes the point that by virtue of their previous reasoning, that is the issues that we've discussed already, and the conclusions in respect of the two substantive issues concerning the quorum required for the House to A, proceed with the business, and B, determine a matter by votes, it is both obvious and implicit that any other rule, procedure, or practice that has the net effect of overriding the presiding member's right to be counted in forming a quorum, as well as votes on a decision, is to that extent now void and of no legal effect. Consequently, no proceedings of Parliament can be invalidated by reason of the fact that a member presiding has exercised his or her constitutional sanctioned right to be counted for quorum and to vote in a decision. Accordingly, the decision of the House on the 30th of November 2021, whereby it approved the 2022 budget, was in accordance with Article 102 and 104 of the Constitution, and for that matter, valid and unimpeachable. You recall the argument have been made by the NDC that because the quorum requirement for such a voting on the budget was half of the members of Parliament, and George Seuss, who was presiding, he could not have counted himself as part to have formed a quorum for the MPP MPs to on their own approve the budget. The Supreme Court says once that's held that the Deputy Speaker could be counted as part of the quorum formation for decision making, as well as adding him to be part of having voting rights even when presiding, it follows through that if any such thing occurred with regards to the budget, then that is to say that that particular action was valid. And so it ruled that the approval of the budget on the 30th of November is valid.
Joseph, thank you very much. And that's just a bit of it for you. This is a very detailed reasoning of the Supreme Court, and you can find it on myjoyonline.com for your own reading. Very detailed indeed, giving and providing detailed reasons for the decision that they're taking tonight. I want to stay in Parliament for a while longer. Let's stay in Parliament now because Parker is joining me. Parker, what really is happening in Parliament today? Because it appears that the House can't simply get the numbers they require to do business. Yesterday, 2 days ago, was it? They had to, abruptly end because they didn't have a quorum. The quorum that we've been debating and they become a Supreme Court matter. It appears it had come up again today. Tell us more.
Yes. The issue came up on the floor of the House today, and the minority has been alleging that most of the NPP MPs are with the president in Dubai, and some of them are also in their constituencies because of the internal polling station election. And so it appears that they have neglected the chamber. So Al-Hassan Suhini, the Tamale North MP today, raised the matter on the floor. Per the standing orders, Order 48.3, the Speaker would have to give them about 10 minutes to ring the bell. The bell was rung. About 40 minutes, the Speaker had ignored the Tamale North MP. And so he sought to, catch the eye of the Speaker. And there was a bit of a near war of words between him and the Subin MP, who accused him of disrespecting the Speaker. We can listen to what transpired in Parliament earlier today.
Yes, Honorable. The Speaker, with deference to the Chair, that portion that the Member of Parliament for Tamale Central is not interested in Tamale interchange, I wish to make appeal to my colleague on the leadership to withdraw that portion of the statement because, Mr. Speaker, I'm doing this because the Member of Parliament for Tamale, together with the leader of the minority, had a press conference on this Tamale interchange. And we all know, and you yourself, you said that. So to say that on the floor of the House, and later, within 5 minutes, to conclude to say that they are not interested, Mr. Speaker, is highly not only contradictory, but unfair. But I think that portion is an affront to our rules and our standing orders, and must be expunged from the bodies.
Yes. Okay, Mr. Speaker, if that part of the statement didn't go down well with my colleagues, I sincerely withdraw it.
Very well. Yes.
Thank you, Mr. Speaker. Mr. Speaker, the member of Tamale South, Honorable Sohini, Tamale North, Honorable Sohini, raised a forum issue. The moment he raised the first one, Honorable Eugene used a language which is not allowed in this chamber. That what type of foolishness is that? And when he was about to leave they were hooting at him. Mr. Speaker, it's not fair. They should withdraw it and so that we move on. Because we don't form a quorum. Frankly speaking, we don't form a quorum. So if we are not going to work with it, then they should withdraw those ones and stop those hooting. Why should you hoot when somebody raises a legitimate issue?
Honorable Member for Mampong, can you resume your seat? Yes, please resume your seat.
come to you.
It's not fair.
Honorable Member, anything that is said into the mic to my hearing, I'll rule on it. As for comments outside, there are no matters that are before me on which I'll rule. If there was any such thing into the mic, it will be part of the record and I'll rule on it. But comments outside, I pretend not to hear them even if I do. That is how the business of the House is done.
Very interesting, exchanges on the floor there. Hassan Suhini himself is joining me right now on the telephone line. Mr. Suhini, so you raised a quorum. From what we've heard there, were you given a proper hearing?
Well, Evans, clearly that the Speaker himself will admit that he did not give a proper hearing to the issue that I raised. And I raised it based on Article 102 of the 1992 Constitution that says that a quorum of Parliament, apart from the person presiding, shall be 1/3 of all the members of Parliament. And I further quoted Order 48.2 of our standing orders, where it is indicated that in the process of a sitting, if a member notices that a quorum is not formed, you can raise that issue, and the Speaker will take a decision within a 10-minute interval after ringing the bell and calling for a count to be taken. So I raise, these issues based on these provisions in the Constitution and in the standing orders. And the Speaker admitted the motion, went ahead to call for the bells to be rung, and asked that a count be done. I sat back, waited for more than 25 minutes, even though the standing order says 10 minutes interval. I sought to draw the Speaker's attention by rising to my feet again. I was ignored, and even the minister who was answering questions tried to draw the Speaker's attention to the fact that I was on my feet. The Speaker went ahead to ignore me and suggested that I was behaving inappropriately, when all I was doing at that point was just to stand to draw his attention, and my intention was to draw his attention to the fact that we had run over 25 minutes since, he called for the bells to be rung. But, he wouldn't recognize me and went ahead to cast certain insinuations and aspersions, and that is what the deputy whip was also trying to draw attention to, and it encouraged other members on the majority side to also engage in some reckless behavior. But he endured that, But you see, Evans, my intention, and maybe the intention of some of us on the minority side, is to make our government more responsible. I think that they have gotten away with too much because we all have been seeking to cooperate to help them govern, but it doesn't look as if they are ready to govern. Look, since this sitting started, there is no day, and your reporter will confirm this, that the minority members are not the reason why the House is even able to sit. Today, before I raised the issue of quorum, there were only about 25 members on their side. We were over 40. We have always, produced the numbers for the House to go on. But we know that Parliament, by the nature of our Parliament, it is constituted to carry out government business. It is constituted largely to do government business. Yes, the issue was raised today that at the time I raised the quorum, it was private business that was taking place. I was fully aware of the fact that it was private business because members were asking questions of ministers, questions related to, issues in their constituency. But because we want to make this government more responsible, I waited until our members on our side asked all their questions. And then I raised the issue of quorum so that they will become more responsible later and whip their members to come onto the floor for us to do either private or public business. Because the Parliament is constituted to carry out government business, and it should not be left on the shoulders of the minority every time to ensure that Parliament is properly constituted for business to be carried out.
So if you counted, then the numbers were not up to what the constitutional quorum is. We know that yesterday or the day before, it compelled the House to simply stop sitting and adjourn. Did that happen?
It didn't. The Speaker simply ignored that, went ahead with business, and that is why I thought that I could not stay in the chamber and continue to watch.
Oh, so you left the chamber.
Standing orders.
So you left the chamber.
Yes, when I realized that the Speaker was simply, and you see, I was not even forcing the Speaker to adjourn the House. I mean, at some point, he suggested that the standing orders gives him so much powers, and that he can even suspend the standing orders and allow business to continue. So, Evans, what I was simply seeking from the Speaker was for him to pass a judgment on my motion, to rule on the motion. Even if his ruling was going to be that because of the seriousness of the private business the House was engaged in, I am suspending the standing orders so that business can carry on. He just needed to do that. But not to, treat my motion with disdain, with disregard, and to just ignore the processes and violate the constitution and violate the standing orders in the manner that was doing.
Parliament is a house of records. If you really and the voting proceedings will show the numbers. Is it something you plan to take on beyond today?
Well, I was not very happy with leadership also on my side. I will engage further with them.
Why were you not happy with them?
Advise myself because I think that sometimes the leaders have certain leverage that they need to use in situations like that to get the Speaker to act in a manner not to violate the standing orders and the Constitution. I didn't see that coming from the leadership at the time, and I wasn't too happy, and I made it clear on the floor before.
So your leaders didn't give you the support you were expecting?
Well, the leader that was present at that point, it was one of the deputy whips that was sitting in front.
Is it Mr.
So it's not the entire leadership. So I'm going to discuss with the leadership and whatever avenues are available to seek redress, I will do that. But I think that the Speaker must change his attitude towards some of these things. You cannot.
I'm grateful, Hassan Suhini there. That's the Member of Parliament for Tamale South there, who today had raised a question of quorum, had come up before this week, and the House was forced to adjourn. You've heard him. What's your take on that? That obviously is a top story, always brought to you by Vodafone and Prime Insurance. Ghana Connect starts